Hello visionaries, welcome back to my channel. My name is Marisa Talbert. I am the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. How many of you create content for your business? Whether it's a YouTube channel, a newsletter, a podcast, marketing material, or some other type of creative content. All right, we in the building. Content creation is not a trend. It is a billion, maybe even $1 trillion industry. So if you haven't started to create content for your business already, the likelihood is that you may start very soon. And the question of the day is, as a content creator, how familiar are you with copyright laws? We don't know what we don't know. Content creation falls squarely within the protection of copyright laws. So it's important that you have a working knowledge of those copyright laws, not only to enforce and protect your rights, but also so that you don't infringe on someone else's rights. So today I'm giving you 10 copyright laws that every content creator should know. Let's jump right into it. Number 1, original content. Now, there's nothing new under the sun, but copyright law protects original works of authorship fixed in a tangible medium. All that means is that the work must be original and that the copyright protection attaches as soon as the work leaves your brain and is expressed in some tangible way. What does that look like? That's once the lyrics are written on paper, once the choreography is danced on the stage, once the sound of the melodies are heard from the instrument. Your content must be your own and it can't be copied from someone else in the exact same way as someone else expressed it. Number 2 is exclusive rights. Copyright protection gives the creator 5 very specific exclusive rights. Those are the rights to reproduce or make a copy, the right to distribute or give it out to others, the right to perform or make it public, the right to display or showcase to others, and the right to create derivative works, like a sequel. Others must seek permission from either the creator or the owner of the content in order to use that content in those ways. Number 3 is the fair use doctrine, which we've talked about before. Fair use allows the limited use of copyrighted material without permission for very limited purposes, such as criticism, parody, education, commentary, news reporting, or research. Factors that are used to determine fair use include the purpose and use of the content, the amount of the content that's used, and the effect on the market value of the content. Number 4 is the public domain. Works that are in the public domain are generally not protected by copyright law and are able to be freely used by anyone. But don't confuse public domain for works that are accessible to the public. Just because content is posted online and accessible to the public does not mean that it's in the public domain and does not have a copyright owner. The public domain has a very specific definition. This refers to works whose copyright has already expired or the work was never able to be protected by copyright in the first place. So these works are not owned by any party and they are not subject to copyright law. Number 5 is Creative Commons licenses. Creative Commons licenses allow creators to grant permissions in advance for how their work will be used by others. For example, let's say that you're a photographer and you want to license your photos for use in blogs and online magazines. You can upload your photos to Creative Commons so that you can still control how those photos are used. Creative Commons licenses range from allowing any use of content with just merely attribution or giving credit to the source, all the way to restrictive uses that limit derivative or other commercial uses. Number 6, registration and duration. As I mentioned earlier, copyright protection is automatic upon the creation of your work once it's expressed in a tangible way. However, registering your work with the U.S. Copyright Office can add additional benefits, and that registration typically lasts for the life of the owner or creator, plus an additional 70 years. Number 7 is infringement consequences. Of course, as a content creator, you need to know that using copyrighted material without permission can lead to legal consequences. This can include lawsuits, fines, penalties, and removal of the infringing material from online platforms. Number 8, you need to be aware of the DMCA or the Digital Millennium Copyright Act. The DMCA is a law that gives copyright owners the ability to request the removal of their infringing content from online platforms. For example, if someone is infringing on your copyright on Instagram, you can file a copyright infringement report with Instagram to have that content removed. Alternatively, if someone is infringing on your copyright on an online platform that doesn't already have a mechanism for how to report those types of claims, then under the DMCA, you can send a DMCA notice, which will request the online platform to remove that copyrighted material. If you need a DMCA takedown notice, you can grab one at the TLO marketplace. And if you've received a DMCA takedown notice and you need to respond, you can also grab a counter notice response at the TLO marketplace as well. We got you covered. Number 9 is moral rights. Moral rights protects the personal and the reputational interest of a content creator. This can include the right to attribution, which means the right to get credit for things that you have created as a content creator. And it also includes the right to object to derogatory treatment of your work. These rights vary by jurisdiction and are usually not acknowledged in the United States, but they do exist. This is why reading and understanding your contracts are so important. Speaking of contracts, number 10, we have to talk about a work for hire clause. Under a work for hire clause, which is a provision in a contract, if you create content as part of your job, the employer that hired you for that content owns that content that you created, unless your contract says otherwise. So it's very important that if you are hired to create content in any capacity, that it is very clear that you understand who owns the rights to the content that's created in various contexts. Well, that's all I have for this video. Understanding the key aspects of copyright law as a content creator can really help you avoid legal issues and help you enforce and protect your own rights as a content creator. So I hope this video was helpful. Don't forget to like, comment, share, and subscribe. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. And I'll see you in the next video. Bye. I done made it this far. I'ma keep it pushing, yeah. Even